This video is going to discuss punitive damages. We're going to start with our Griff versus Curry Bean Co. case. What happened in this case? Well, Griff, which is our plaintiff, grows beans, and Curry Bean, which is our defendant, mills and markets these beans. So C pays G the price of the beans sold to the third party minus a $3 milling and mining marketing charge per cut. In 1996, G delivered 39,000 cuts to C that C claims it sold. The issue is, when did C sell these beans? G argues that the beans were sold in 1996 for $28 per cut, which is the higher amount. But C argues that the beans were sold in 1997 for $27.50 per cut. After the trial, the evidence suggests that the beans were sold to cover C's short position and not actually for the market, which means C sold their beans first at a higher price and then sold G's beans later at a lower price. Hull, which was C's agent, later altered this DPR, which is the daily position register, a year later in 1998 in anticipation of the litigation to show that C purchased the beans in 1997 instead of 1996. What does that mean? Well, in 1996, C is short on beans and G is delivering these beans, right? So C's inventory is short. So C uses G's beans that were delivered as its own and sells them at a higher price to take a higher profit. Then C claims in 1997 that that's when it actually bought G's beans at a lower price to cover its shortage of beans, not in 1996. It claims it used its own beans in 1996. And then later in 1998, it altered its daily position register to match this claim. The lower court's holding basically said that G sued C for breach of contract and that C was liable, and the jury awarded compensatory damages and punitive damages of over $500,000. And now C is appealing. So at the appellate level, what are the issues addressed by the court? Well, there are two issues. One, was there enough evidence to support an award of punitive damages? And two, was the award of punitive damages excessive, if we're even allowed to award it? The appellate court said, yes, we can award punitive damages in this situation. And no, the award is not excessive. What were the rules the court used to determine these holdings? Let's deal with the first issue. The court said that punitive damages are not favored in law and should not be awarded and should only be awarded in the most unusual and compelling circumstances. So they didn't say that punitive damages are always available, but they're appropriate in this case because the actions by Curry were oppressive, fraudulent, wanton, malicious, or outrageous. For the second issue, whether this award of punitive damages was excessive, the court had a pretty long rule statement on page 850. And so we need to break this down into a rule statement that you can actually use on the exam. We have our first rule from the first issue, which is when punitive damages are available. And for our second issue, what is the court saying is the rule to use if we broke it down into something besides a giant paragraph? Well, a punitive damage award is considered excessive if the award appears to have been given under the influence of passion and prejudice. To analyze whether something was excessive, we look at the following factors: whether the award would deter others, the motives actuating the defendant's conduct, the degree of calculation involved in the defendant's conduct, and the extent of the defendant's disregard of the rights of others. So this is a pretty hefty rule statement to remember. How can we make these rules easier to memorize? I usually encourage students to make up acronyms where they can memorize things. So we have FOMO-W, which is fraudulent, oppressive, malicious, outrageous, or wanton. For the second sentence, you can just abbreviate it, which is excessive equals under the influence of passion or prejudice. And then another strategy is just letters to remember things in the beginning, similar to this. So it's excessive, and the factors we look at are whether it deters others, the defendant's motives, the degree of the defendant's conduct, and the defendant's disregard for others. Easy to remember, it's the 4 Ds. Another side rule that showed up that's good to remember is to recover for punitive damages against a corporation, which is what we're dealing with here, Curry Bean Co., one must show that an officer or director participated in or ratified the conduct underlying the punitive damages award. But the big issue here that I wanted to discuss is whether the defendant's wealth should also be a factor. We had the compensatory damages of $500 over $1,000. And then we had the punitive damage award, which was $93 plus $1,000, which means our compensatory damage award was about $400,000 plus. The punitive damage award was about 48% of Curry's value. Now, thinking about the underlying action, which is breach of contract, would a punitive damage award be appropriate in this situation to punish Curry and or deter Curry or other similar defendants from doing this conduct? The company's worth would be about 187K if you did the math. Well, the court held no, the award is not disproportionate to the compensatory damages awarded because of C's dishonest conduct. And they think that it's appropriate to deter similar conduct by C and other bonded warehouses. But what if the punitive damage award was actually 90% of Curry's value or 20% of Curry's value? That would mean the company is worth 130K or the company is worth 467K. Same question. And it depends. For 90K, maybe not. You might bankrupt the company if they're going to have to pay 90% of their value. And 20K, the company might not even care because it's so little where it might not deter them at all. And they might continue doing this bad behavior. And so that was to illustrate this last factor, which is should the defendant's wealth be a factor? And the answer is, well, yes, it relates to deterrence, like I just said. Wealthier companies might have to pay higher punitive damages to be deterred. So if Curry is worth more, you have to pay higher punitive damages to prevent them from doing it again. If they're worth less and the punitive damages are too high, it becomes punishment where they're going to be put out of business. So defendant's wealth is considered, which means we actually have 5 Ds that we look at as factors when determining the excessiveness of punitive damages. Now let's move on to State Farm, which gives us even more rules about punitive damages. And so what happened here? Well, our plaintiff negligently caused an accident that caused one person to die and permanently disabled another. The plaintiff's insurance company, State Farm, didn't settle the claims with the victims for $50K, which is $25K per piece. These cases went to trial, and the jury held the plaintiff, Campbell, liable for $185K plus in damages. State Farm has refused to cover the excess liability, and the victims have now agreed to release Campbell in exchange for 90% of the proceeds of Campbell's bad faith action against State Farm. There was a whole national scheme at State Farm to cap the settlement awards or the settlement of claims for its clients with other victims, which is why it said it didn't want to even settle for the $50K. And so Campbell lost the appeal against the victim, so State Farm was forced to pay this $85K judgment, but Campbell still filed this claim for bad faith fraud and IIED. And so how does this work procedurally? What was going on that makes this a punitive damage case? Well, the jury in the first case against Campbell against State Farm awarded $2.6 million in compensatory damages and $145 million in punitive damages. The trial court reduced the award to $1 million in compensatory damages and $25 million in punitive damages. And then the Utah Supreme Court kept the compensatory damages at $1 million, but reinstated the trial court a holding of $145 million in punitive damages. And now we're at the U.S. Supreme Court. So the highest court in our land is now determining what is appropriate, what is punitive damages appropriate, and what's the appropriate amount that should be awarded here. And so the main takeaway here is that 3-factor test that the U.S. Supreme Court used to make this decision. And they reference Gore, which was in 1996, a case in 1996, that stated courts reviewing punitive damages must consider 3 things. 1, the degree of reprehensibility of the defendant's misconduct. 2, the disparity between the actual or potential harm suffered by the plaintiff and the punitive damages award. And 3, the difference between the punitive damages award by the jury and the civil penalties authorized or imposed in comparable cases. The court included several sub-rules or additional factors you consider under each of these 3 factors that explained, when a defendant's conduct is considered reprehensible. So for the first one, you want to consider whether there was physical harm, not just economic. Was there indifference or reckless disregard for the health or safety of others? Or did you target someone with financial vulnerability, a repeat offender, or is it just an isolated incident that might have happened by accident? Intent, deceit. You want to look at, well, how bad was the defendant's misconduct in this case? The second factor you want to look at if the potential harm or actual harm suffered and the actual punitive damages awards have some relationship. It needs to be reasonable and proportionate. And one of the rules that came out that is a very easy one or good one to put in your analysis is this instructive ratio. The court said that the award of punitive damages should not exceed a single digit ratio. An award more than 4 times the amount of compensatory damages might be close to the line of constitutional impropriety. The third factor is pretty self-explanatory, where you want to just compare the punitive damage award and see if it's close to the amount that is awarded in civil penalties. You can also look at criminal penalties because those can bear on the seriousness on which the state views the wrongful action. The punitive damages are excessively higher than the criminal penalty or civil penalties, well, it might be unconstitutional. What was the Supreme Court's holding and why as to whether State Farm had to pay this $145 million punitive damage award? And they decided, no, it's too high. For the first factor, they said you can't impose punitive damages for unlawful acts committed outside the state's jurisdiction on hypothetical claims or actions against other plaintiffs or for being unsavory. So they basically said you can't say, oh, they have this national scheme to defraud all of their clients in all the different states, and now we're awarding $145 million in punitive damages for all these plaintiffs' claims that are not actually at issue here. For the second factor, the court said a 145-to-1 ratio is not reasonable, especially when there are no physical injuries. It's only an economic harm that was suffered by Campbell. The underlying claim where Campbell's victims suffered physical injuries or death, now that's not what we're dealing with. We're dealing with an insurance claim here. It's a different issue. So we can't just consider the impact on all Utah customers or awards from other states. We got to just look at Campbell's insurance case. We also can't look at the probability of State Farm not being punished in other states or for other consumers. We can look at State Farm's wealth, which is probably pretty high as such a big popular company, but we can't use it to inflate these awards unfairly. And then finally, when they said, oh, we're looking at the difference between punitive damages and civil penalties, where we're looking at the loss of the business license, disgorgements of profits, possible imprisonment with speculative evidence drawn from out of state and dissimilar conduct, it's insufficient to justify this award. The final decision was it's not reasonable nor proportionate to the wrong committed. It was irrational and arbitrary deprivation of property of the defendant. And so why? Well, let's compare it to the Griff v. Curry Bean case. Griff v. Curry Bean, the punitive damage award was $93K. And then in State Farm, the punitive damage award was $145 million. There was fraud in the Curry Bean case, and there's fraud at State Farm for this national scheme to meet corporate goals by capping payouts on claims company-wide. So one's a little bit more high scale, but the actual conduct or bad conduct was just fraud. They're the same. However, the award in State Farm was $145,000 more than the compensatory damages suffered. And in Griff v. Curry Bean, it was not even twice the amount of compensatory damages. And so here you could see why in Griff v. Curry Bean, they upheld the award of punitive damages, versus in State Farm, they didn't uphold it. And so what amendment did the US Supreme Court reference to analyze the constitutionality of the jury's $145 million punitive damage award? Well, it was the 14th Amendment. Specifically, the due process clause that prohibits grossly excessive or arbitrary punishments because those are unconstitutional deprivations of property, and saying the due process clause requires fair notice. That means State Farm needed notice that it could pay $145 million in damages to Campbell by denying to settle the claims with the two victims for $50K. But how do these punitive damages relate to criminal law? Well, criminal sanctions are evidence as how the state views the conduct. So if there's actual criminal sanctions, it's probably pretty bad because it's enough to be punishable. And criminal sanctions also offer an alternative to punitive damages in some cases, but that money goes to the state. The difference is punitive damages, the money goes to the plaintiff. The problem is with punitive damages in civil cases, the defendants are not given all the protections that are applicable in a criminal proceeding. And so that's the whole issue the court has here, is to make State Farm pay $145 million in punitive damages without the protections of a criminal proceeding is unfair, because we're depriving them of due process by taking their property, which is money, away without fair notice or a proper trial. And so here are the two rules on the screen summarized. I encourage you now to combine these rules to make just one attack plan for the exam, which we'll go over in class. But it's something that you want to figure out, well, how do these two relate to each other? And how can I create something that I can memorize and slap down and analyze on an exam rather quickly?